We're live.
Okay. Our first witness, well, I got to do the gut it. Our first witness this morning is Jennifer Pullman. The issue is bail. S-27 is a bill that would remove cash bail from misdemeanors, basically. So Jen represents the Vermont Center for Crime Victim Services. Welcome.
Thank you, and I appreciate the committee allowing me to testify virtually, managing school break and still trying to get some work done. So appreciate the accommodation. For the record, I'm Jennifer Pullman. I'm the Executive Director with the Vermont Center for Crime Victim Services, and appreciate that this committee is allowing for us to speak briefly to S-27 relative to the elimination of cash bail on misdemeanors. The center is very supportive of reform efforts and have really valued the robust conversation that's come through these efforts that have been moved through Senate Judiciary and House Judiciary, and feel that they've been really important. And want to recognize, of course, that we've been a part of the many meetings and the many conversations with CSG and others that recognize that, in fact, there is disparate treatment in this state for individuals of color. And we also see that, on the other hand, in terms of how victims are treated as well, in terms of whether their cases are taken as seriously, their reports are taken as seriously, and also whether they even feel comfortable coming forward to report a crime when there is distrust of the system as well. So we think that these conversations are really important. And I know that the center has been engaging in this work ourselves, both internally and externally, with our 16 communities in the state to really identify how we can make sure that there is equal access to justice, there's equity and inclusion. So it's certainly something that we value. With respect to S-21 specifically, I really want to harken back to the testimony of my valued colleagues last week. And listening to them, I got to thinking about the 20 years I've been in committees in various capacities doing this work. And it got me thinking about, when we talk about policies, we talk about solutions, we've always been really proud about the uniqueness of Vermont. And that while something might be happening nationally, while something might be happening in a neighboring state, that we always have taken a look at what the issues and problems are in Vermont, and then work to identify Vermont-specific solutions. And I heard that many times through the testimony of all of my colleagues last week who've been doing this work for forever. So I'll reflect back on that shortly. So as to Section 2, and I want to start with Section 2, because for me, I think that's the most important part of this bill. And I think it creates the space for an important conversation. We strongly support whether it's a study committee, work group, just the notion of having people come together and have that conversation across the board, not just with respect to felonies. I know it's come up as to whether this should lie with the Sentencing Commission or with the specific group that's been established in Section 2. And I just want to note that the center has a seat on the Sentencing Commission. We have since its inception way back when. The Sentencing Commission is well placed to do this work. That's what you all created it for. And I know that when we have these conversations on different issues, we really come together and put together some really good products, thoughtful recommendations. We call witnesses. We have those challenging conversations amongst us. So I think that the Sentencing Commission could be a great place for this to land. That being said, the network is not on the Sentencing Commission. So if you were to choose the Sentencing Commission, perhaps adding in a language that the Sentencing Commission shall consult with the Network Against Domestic and Sexual Violence. If you were to choose to go with the current way that it is established, the two notes that I have made to myself is that, as you've heard from Judge Zone, the Department of Corrections is not on this list. And also the Vermont State Police or any representative from law enforcement are not on. I was speaking with Commissioner Morrison the other day on another issue, but she did note that she felt it would be important that they would have a voice. So either way you go, I just think it's thinking about those, making sure that all those voices are represented. And I do want to note, I do agree with Judge Zone that the language in terms of the directive to the committee does feel very directive. And that I've sat on many of these off-session work groups, many of these task forces. And the charge is a little bit more broad, and I would like the committee to consider what Judge Zoni was suggesting as far as making it a little bit more of an open charge and open study. So I do want to harken back to that. But that's up to you. But I think we all work together. We respect each other. I've worked with Defender General Valerio for over 20 years. And I think when you put us in a room, we can come up with some pretty good ideas that can represent a solid compromise for Vermont. I'll just touch briefly on Section 3, of course, relative to data collection. We think that's obviously really important. Illinois did a great job with that. And I think that having DOC start to collect that data, perhaps in partnership with Crime Research Group, CRG, would be a really valuable connection that would support them as well. Mr. Chair, you're on mute.
I'm sorry. We actually moved that section to S14.
Still on mute.
Section 3.
Oh.
Pardon me? But we took your advice already.
Oh, yeah, I won today. It's going to be a good day.
Yeah.
No, thank you. I'm sorry, I'm only one person, so I haven't been able to track everything. So
No, I understand.
And I did want to put a plug in for the Judiciary on Section 4. That's certainly not our dog in the race, but just to note that our restitution unit did move towards one of these notification systems, and it has been incredibly helpful for our team and also for working with people who owe restitution and also victims. So I think that it's streamlined it a lot for us. It's really helpful for the people we work with, and just being a cheerleader on the sideline to put a plug in there. So as to Section 1, you've already heard from my colleagues that only 19 currently on the last data gathering are held on bail on misdemeanors, that you had recently changed the bail statutes to make the maximum up to $200 on a misdemeanor. So our numbers are low, and we do think it would be helpful to get further data on breakdown relative to crime and also to race. And also it would be interesting to see if these numbers are decreasing naturally and trending downward. But I do just want to reflect back again on the statements of my colleagues and even the Defender General saying that right now this is not a problem in Vermont. So it seems to be part of a larger conversation that needs to happen, but I think you've heard loud and clear from the witnesses last week. For us, some misdemeanors are very concerning if they were to be included. Obviously, domestic assault, stalking, violations of abuse prevention orders, that's a misdemeanor. Sex offender registry violations, that's a misdemeanor. And I think when we think about VAPOs and SOR violations, generally that's because somebody already is not complying with an order. So that raises an issue beyond even a safety concern. So those are crimes that give us a lot of pause when we take away discretion from a judge to say, you know what, this one's an outlier. We need to think about this one differently, which is not to say that tons of these people are being held, but taking away discretion for some of these misdemeanors is really concerning. And I did mention this to other advocates, and I mentioned it to the Special Investigation Units directors, and they did share with their officers. And they had two main reactions. One, which was, why would anyone show up? Why would anybody show up to court? And the other one is, what would be the meaningful protections for victims then as far as safety? A violation of condition of release is a misdemeanor too. So there was serious concern about how we would be able to enforce any condition in a meaningful way that would provide for victim safety. So crimes such as these, while they're misdemeanors, do need to be studied in a more thoughtful way. And we would ask that if you were to move forward with considering the elimination of cash bail for some misdemeanors, that these crimes would be considered as part of the conversation that the Sentencing Commission or the task force established in Section 2 should have. So at this time, we cannot support eliminating cash bail for misdemeanors completely as written in this bill. There are two other pieces which you did hear about last week from my colleagues I do want to also bring up. It's that need to understand what our pre-trial alternatives here are in Vermont. And again, that's perfect for that conversation about, how do we provide for victim safety? How do we secure attendance? What is the Department of Corrections able to do right now when we're in a pretrial situation? So what is needed and what have other states done? I think that's important. I know that the Sentencing Commission has been working on responsible adult provisions that are already in existence and trying to create language that will strengthen that piece. And I think since some of that work's already being done, that's another alternative that could be built into a more comprehensive recommendation. Finally, you did hear from my colleagues last week as well about some of these unintended consequences. We collectively, and I know that this body wants to avoid that unintended consequence when a prosecutor feels like if they need to go with the felony because the misdemeanor is not going to have that cash bail option. And again, I think that's a conversation that if you put us in a room, we can iron that out. But if we could avoid that piece, I think that's a really important, because nobody wants to go down a different road and create a ripple effect that is not going the direction that this body wants to go. So again, it's about making sure that conversation is happening. We've done this before, we can do it again and create Vermont-specific solutions. I do understand that other states have gone down this road. I do understand also that New York is starting to maybe reconsider some of its pieces and trying to take a more targeted approach versus the more general rollback. But I think that we have an opportunity to learn from other states and learn from other states' experiences. And I think that's what makes Vermont so special, is that we know each other. We know each other very well. We're not this big state and we exist kind of in our own silos. I think it's important to learn from other states and then figure out how that applies to Vermont. We need to know what the guardrails are in our state, and we need to know what the other guardrails potentially could be. And again, I think that's an important conversation that we can have as a state. So I'm simply asking that this committee give us a little bit of space to do this work. I would hate to have us run in a direction that would then have us back here in a year saying, well, this is what we're seeing. I think we can do this well. I have all the faith in the world in my colleagues and really want to think about how we can create a comprehensive approach that is Vermont-based and reflects realities of Vermont. So I want to thank you so much for your time. Thank you for your consideration. And we have always felt that we've had a voice at the table with reform efforts, and we've always felt that they've been a positive outcome when everybody has a voice, and appreciate your consideration of these important issues.
Thank you, Jennifer. Just a quick question. You mentioned a list of crimes earlier that I think you didn't want included. And I agree with that, like domestic assault, for example. I'm not a fast note taker. Can you just list those crimes for me one more time, please?
I didn't identify every listed misdemeanor, and the list of crimes are not always comprehensive in any event. For me, what jumped out was domestic assault, stalking, violation of an abuse prevention order, and also sex offender registry violations, which is, again, not to say that we say people should be held. It's that we are suggesting we don't take discretion away from the judge to look at the situation that's being presented to them. I know reckless endangerment is a misdemeanor that could or may not, but those are the four cases, the four types of crimes that I wanted to focus on, especially with you have stalking has very serious safety concerns, regardless of whether there's even contact. And then sex offender registry and,
Thank you.
so I think, okay.
And Senator Vohosky has a question.
Yes.
Yeah, well, I want to just make sure that we're all clear that bail cannot be used to mitigate violence. It can only be used to make sure someone returns. And there's a fair amount of national statistics that show that it doesn't really work to do that. So I want to be careful about pulling certain crimes out of these conversations that lead us to looking like we are using bail to mitigate violence, which is in direct opposition to the Vermont Constitution.
I appreciate that comment, but my concern is when we have conditions of release for these that are designed to, and that are in our statutes, that are also designed to protect victims and the public, that would no longer be enforceable in any meaningful way. How do you hold somebody accountable and account for victim safety when a violation of condition of release would also not allow for somebody to be held? Because that's a misdemeanor as well, as I understand it.
Well, so this bill does nothing to change conditions of release. It simply would eliminate cash bail, which already cannot be used for anything but ensuring someone shows up in court.
Well, our concern and the concern of advocates and detectives that do this work is that this provides no meaningful way to respond to a violation of prohibition of contact or some other piece that's designed to protect victim safety.
Thank you.
Well, that leads to
I don't really have.
my other question. And Michelle, maybe you can help me with it, but what happens to those that fail to appear? They are released on their own recognizance, I'm assuming, and then there's been a series of misdemeanor crimes, and they just fail to appear. And does this change that at all? You're muted, Michelle.
I don't believe so, but let me follow up and I'll check and I'll get back with you on that.
Because that's certainly another group that, the bail statute is designed to ensure
Right.
appearance in court. And if you don't appear in court, what can we do? I'd hate to see that exasperated because I understand that during the pandemic, we've lost many people who have just failed to appear and either have disappeared or whatever. So I want to make sure that's still cold.
Sure. Let me check with folks who are doing that now so I understand the process for that and how they're doing that currently.
All right. Any other questions for Jen or for Michelle that's risen from Jen's testimony? Thank you very much, Jen. Appreciate the testimony. And
Thank you very much. And Mr. Chair, keep getting better.
thank you. I'm trying. The next witness is Al Johnson Kurtz, Steering Committee for Vermont Freedom Fund. At least that's the title I was given.
Thank you, Senator Sears. Good morning, everyone. My name is Al Johnson Kurtz, pronouns are they, them, and I have been on the steering committee of the Vermont Freedom Fund since 2018. So I want to share first about some background on bail, and I'm sure a lot of it is things that you've already heard, but I do want to have that on the record. Share a little bit about the Freedom Fund and the work we do, and then some calls to action. So first, bail creates a two-tier system, as I'm sure you know. Those awaiting trial who have money can be sent home to their communities, and those who don't have money end up in jail simply because they can't afford to pay bail. And that's where we come in. Unfortunately, when people are incarcerated, they often lose their jobs, their housing, even their kids. Their lives and communities are irreparably disrupted. So when we can avoid that, it is crucial that we do so. And bail disproportionately harms poor people as well as people of color who are more likely to experience bias when bail is set. As we just noted in the Q&A there, legally, bail cannot be used to keep people accused of violent offenses from being in the community. It's deeply concerning to me that it seems like bail in Vermont is being used in an attempt to hold people in jail. If it's clear in advance of a trial that significant violence has been committed and people may be in danger from someone, other tools need to be used besides bail to prevent that person from committing additional crimes or harming other people. Bail cannot legally be used to try to prevent violence in our communities. It can only be used to help ensure that someone shows up for court. And then I just want to speak to the failure to appear piece as well. We have seen with the bail fund that people are charged with failure to appear because they had no phone or no address. So they did not and could not know about their court date. And that causes a trickle down ripple effect that impacts their lives for many years to come. And so a new solution needs to come so that people can know about where and when to show up, because in our experience, people do want to show up. They do want to get their lives back on track, and transportation is also an issue. So we have heard from folks who we've helped that they were not trying to avoid prosecution, but their failure to appear will be used against them in setting higher and higher bail. So just some background on bail there. I want to speak about the Vermont Freedom Fund. We are a volunteer-run 501c3 tax-deductible fund. We're connected to the National Bail Fund Network, which links together and supports collaboration between bail funds all around the country. And we bail out incarcerated community members in Vermont. We work with people who are detained and their legal counsel to provide the bail funds that they need in order to be released, to reduce this two-tier system that we've set up in Vermont, the impacts of this two-tier system. We believe that cash bail is an abuse of the criminal justice system, that it criminalizes poverty and has a disproportionate effect on Black people, Indigenous people, people of color, immigrants, et cetera. We firmly believe that wealth should not determine who is kept in jail. And that's what we are experiencing right now. We were founded in 2018 alongside Migrant Justice when their leadership was being illegally targeted by ICE. And that was before Migrant Justice and several immigrant community leaders received over $100,000 in damages from ICE for that illegal targeting. And so after that, that settlement happened, in 2021, we began paying community bail and shifted our focus a little bit because there was less need for the immigration bond support. And we have just seen that the community bail need is great, and we do not have enough money to meet the need. We fundraise as much as possible and pay as many bails as we are able. But every person for whom we post bail doesn't have the money to post bail. And bail is supposed to be set at an amount that someone could reasonably pay, and that's not happening. People simply don't have the funds, and so they're being kept pre-trial, before their trial, in jail because they simply can't pay. So we are able to come in since paying our first pre-trial bail, which was in 2021. We've posted bail 39 times and for a total of almost $50,000. In 2023 alone, we've posted bail for 11 people for a total of $8,850. And over the course of our community bail work, we've paid bails ranging from $50 to $5,000. So happy to answer any more questions about the bail fund. I'm going to move on just to our calls to action. First of all, we just see that there's too much discretion with bail.
Presumably, when you were talking about, I do have a question. When you were talking about $5,000 cash bail, you're presumably talking about felonies and not misdemeanor cases.
I could look it up if you would like to.
I mean, I wondered, how much of a problem the misdemeanors are. That's like, I guess that's the heart of the question. Since this bill in section 2 would eliminate for all misdemeanors. Excuse me, section 1.
Yep. So I don't have the data right now for, I do have it, but I would need to look it up for the prices. I'm just giving you an overview of the freedom.
Yeah, understood.
And our,
Okay, I'm just curious as to how many cases are actual misdemeanors versus felonies.
Sure,
Will you help people with the bill?
I'm sure it's both. And I would need to go back through our data to see what, like, if you wanted to know, like, the maximum misdemeanor bail that we had paid.
Yeah, that would be interesting. You may not have it right on, it may be difficult to gain, and that's fine. I'm just trying to get a sense of the difference between the misdemeanor bail, where bail is set, and felonies, which would appear to be when you're into the 5,000 on the felony.
It very well may be. Yeah. And so, and I'll just
We heard testimony that very few people are held on bail, cash bail, with misdemeanors in Vermont.
Well, I think it's still an important move in the right direction. And our position from the Freedom Fund is that bail should be eliminated entirely. I think that any move in that direction is a good thing. And if we can save even one person from being in jail unnecessarily pre-trial, that's going to improve a life. So that's where we're at with it. But our position would be to eliminate it entirely.
Appreciate that. Thank you.
Yeah.
Go ahead.
All right. For the calls to action, first off, we just see that there's too much discretion with bail. And you may have seen the article or been there firsthand for Judge Rainville self-describing himself as the bail judge and seemingly intentionally creating situations where people were kept in jail for inability to pay before they'd been to trial. And we need to eliminate cash bail, and starting with misdemeanors is a good place to start for more consistent outcomes, no matter where you live in Vermont. It is unconscionable that people are able to shift the trajectories of people's lives because we don't have a consistent system across the state. And then we need to take action to make sure people know about their hearings. I have talked with people, we also provide transportation from jail for folks. And I've spoken with people who simply didn't know that they needed to appear but wanted to do so. And so I was encouraged to see the piece about expanding the ways that people are alerted about their hearings so that they can make the choices to show up should they want to do that, because folks are not getting notified in a way that's working. And then in terms of section 2 about the group of stakeholders, just want to emphasize that group should be about coming up with new innovative solutions, and that the groups who are included in making that proposal should reflect that goal of creating new ideas that will help move us forward and support all the community members in Vermont. And so we need to have representation from people who have been impacted by bail. And also the Freedom Fund would like to be included in that group of stakeholders creating a proposal to eliminate cash bail. So I wanted to add that as well. Happy to take any questions.
Are there any
Thank you, Al.
questions?
I appreciate a lot of your testimony, and I have more of a comment, and then if you have any thoughts on it, I'd love to hear it. But what I'm grappling with is the fact that bail is not supposed to be used for mitigating violence, but at least in part and in practice and spirit, there is part of it that's used with the hopes of mitigating violence. And the thing that I go back to often is the domestic violence case where the crime is committed. There's some other, and it's a misdemeanor, but there's some other circumstances that causes the person to be held with bail until their hearing or flash cited for the following day. And while part of it is to mitigate the flight risk, there's also the relief knowing that the victim will be safe for that night. But again, the bail isn't supposed to be used to mitigate violence. So that's something that I'm kind of grappling with here. And I agree 100% that there's also circumstances in which bail will be used and it will have a negative impact on BIPOC folks. And I saw this a lot in the Windham County area where we're bordering Massachusetts and New Hampshire, very close to Hartford and New York. And when it comes to drug interdiction, a lot of folks would end up being held with bail because they were from another state. And it did have a large impact, a negative impact on BIPOC people from what I saw. So yeah, I don't really have a question. I'm just trying, I feel like there's a lot of things that need to be reworked in general, and I'm not sure what the answer is. So, yeah.
I hear you. And it is a significant issue that people may be in our community who have committed, have harmed someone and then may do so again. And I just want to reiterate, bail cannot be the tool. It is illegal for that to be the tool that is used to attempt to prevent that violence. We need to come up with other tools, and that's why I'm excited that you have the group in place in this bill to help come up with some of those solutions. And I want to reiterate that that group should include organizations and individuals who can think outside the box and come up with new and creative solutions, because what you're describing is a problem. It's just that bail cannot be the tool that's used to solve it, because that's illegal.
No, I also had a bit more of a comment. Thank you, Al, for your testimony. And I have to say, I'm in agreement that when we're looking at this issue and some of the testimony we've heard has really led me more in the direction that eliminating cash bail entirely is what we should be doing. And I'm gonna be sitting down after the break to sort of talk through with some of the people who have testified and been here to sort of think about how we potentially revamp this to make sure that we are both building a system of accountability and breaking down the inequity within our bail system. So I appreciate you sort of just coming to put forward what you were seeing and for the work you're doing.
Thank you.
Are your services statewide?
They are, and we have a focus. We decided as a group to have a focus on CRCF and supporting women in CRCF. That's not all we do, but we do end up being tilted in that direction.
Thank you.
Senator.
Yeah.
Al, do you have a sense of how many people, and maybe you don't have this right in front of you, but how many people have asked for your help that you're unable to help?
Oh my goodness. So the primary way that people contact us, we tried to have a phone line, and it was a phone line that could route between our 6 different steering committee members. When I was on duty, I would get calls multiple times a day on my phone. Because we are all volunteer, we were not able to keep up with that. And so we shifted to a system where people write us letters. We receive many letters a week. And it's heartbreaking hearing kind of the situations of people's lives of wanting to get back to their kids and being worried their kids are going to be taken and they're awaiting trial, losing their housing because they're in jail, like just seeing in people's own handwriting the situation. I don't have a number right now, but it would be an interesting one to try to find. It is large. We do not have the resources to meet all the need.
Thank you.
Okay, other questions? Thank you very much for being with us this morning.
Thank you for having me. It's great to be here, and I'm available by email if anyone has follow-up questions.
Great, thank you. The next witness is Indy Schaffer from ACLU. Is she with us? Oh, you're in person. Okay,
yes,
great.
I'm in person today.
Great, welcome back.
Thank you. This is my first time in this chair, and I'm grateful to be here. A little nervous, but I'm trying to
Don't be, please.
keep my remarks short. But Indy Schoen here for the record, policy advocate at the ACLU of Vermont. Thank you for the opportunity to testify on S27. The ACLU of Vermont is committed to ending unjust and inequitable practices in our criminal legal system that harm our communities. And everyone should have equal protection under the law. But what we're seeing is cash bail is one of the most unfair aspects of our criminal legal system. In Vermont, access to one's community should be the norm, and detention should be rare. And this decision should be based on should be based on multiple factors and not on how much money someone has. So just as we heard from Al, cash bail disproportionately hurts those who have less money. We are all aware of the economic challenges that a lot of people in this state are facing today. And our cash bail system forces households to choose which of their needs will be met. So people who can't afford to pay bail must remain in jail pre-trial, and they're at risk of losing their jobs, homes, and even custody of their children. And so freedom, again, should not be determined by how much money someone has, and to continue this unfair practice actively perpetuates inequity in our criminal legal system. I want to touch on pretrial detention and how it damages community ties. Putting a person behind bars who has not yet been found guilty is one of the most severe restrictions the government can place on a person's liberty. And Vermont has a uniform correction system, meaning that our corrections facility holds both sentenced and detained population. And what we're seeing is people are being forced to wait in prison until their cases can be heard. And at this time, when the court system is delayed due to backlogs from the pandemic, it just puts people in an unfair position to not being able to afford bail at this time. So we're also seeing that our cash bail system is a driver for incarceration and perpetuates our over-reliance on prisons. Even short periods of unnecessary detention increase a person's risk of rearrest. So eliminating cash bail would not only address some of the economic injustices of our country, it would also reduce the number of people held in our prisons pre-trial. So this legislative body has done immense work to reduce our prison population, and we see this legislation keeping us moving in the right direction. So off that, we do see this as the logical next step in our state's work to create a more just criminal legal system. Looking at some of the data from Department of Corrections, I wanted to get a sense of how many people are being held pre-trial for misdemeanors, who are being held for misdemeanors in our department, in our facilities, and there are about 37 people. And if in effect today, this legislation could potentially impact those 37 people. They could go back out into their communities, they could be with their families, there are a lot of things there, but just to keep that in mind, 37 people are being held for misdemeanors. So in addition to the incalculable harm that work-based incarceration forces on our communities, the continued risk of bail also has tangible physical ramifications for our state. So this detention is based on not the risk that they present to the community, and it costs Vermont taxpayers, this number is large, it's $95,292.82 per person per year. That comes out to $261 per day, and this amounts to millions annually. So we're supportive of this legislation in ending the imposition of cash bail on misdemeanors. And we also think it is so imperative to continue to study how we can do this effectively, so that we are not running into some unintended consequences. And I just want to go off of what Al said. When looking at the stakeholders, I do think it's important to have representation of people who are directly impacted, and also organizations who are willing to think outside the box of how we can end cash bail outright. And the ACLU would appreciate the opportunity to be part of this working group as there are intersections with civil liberties and civil rights there. So in conclusion, we support S27 as an essential step to create a smarter and more equitable criminal legal system that allows for people to be in their communities regardless of the amount of money they have in their bank account. Everyone should have equal protection under the law, and cash bail imposes undue burdens on people with lower income, robbing them of essential freedoms. So we urge the legislature to move forward with this bill. And if you have any questions, I'm happy to take them. Thank you.
Are there questions?
Not seeing any in the room.
So I'll jump right in. Section 2 of the bill sets up a study. Some have suggested that it's better to have it done by the Sentencing Commission. Others would like it a broader group, and I'm looking at the language as introduced. And both you and the prior witness have talked about wanting to be involved in the discussion in section 2. Thoughts on
Yeah.
how that would come together? We just experienced a group that was assigned to make recommendations regarding a forensic facility. And we had all kinds of stakeholders, and the end result was they couldn't make a decision because the group was so diverse, I guess, or had so many different opinions. So we're now dealing with that bill, but I always worry when we put together groups with the ideal of coming up with proposals, and sometimes it doesn't work. And I know the ACLU has been very much involved with justice reinvestment, and the working group there is along with many other groups. And I'm curious if you have any ideas about section 2.
To be fully transparent, Falco is supposed to be at the chair today, but he's upstairs in corrections. And so I feel like he would have a better idea around what stakeholders should be in this working group. But just thinking about how this does impact people's civil liberties and really wanting to be transparent in our communities, we as the ACLU feel like we can bridge some of the gap between like the conversations happening at the table and what we're hearing from community members as we're engaging in this work. So if there is a way to include us, that would be great, but totally understand y'all's decision to move forward. How you might.
Not seeing any other questions, Senator Sears in the room.
Okay, thank you. Yep.
Thank you.
Thank you.
Michelle, maybe it's time to take a look at, we did move section 3 over to S14. So that's been taken care of. Section 2, I may not be recalling all of the testimony, but it looks like it could use a broader group, but then I don't know how, whether the Sentencing Commission would be the ideal place for that.
Right. So Senator Sears, based on the testimony from the last hearing, I started on a committee amendment. Would it be helpful if I pop that up and we can go section by section and look at that?
Yep, that would be helpful.
All right, I got a lot of documents open. Okay, can everybody see that?
Yep.
Okay. So looking at the amendments in section 1, I didn't change anything with regard to the policy yet. So this is the kind of heart of it around the elimination of cash bail. But I did just do some technical tweaks to the language on the bottom of page 1 and top of page 2. And so it is just so it's a little cleaner. So no bail, secured appearance bond or appearance bond may be imposed at the initial appearance of a person charged with a misdemeanor. So if you decide to, and remember this has a delayed effective date. So if you do decide to keep this section in and you want to perhaps say, with the exception of domestic assault, violation of an APA or things like that, we could do that there in subdivision B2. So that's where we would amend there. The new section 2 is the proposal to eliminate cash bail. And I just kind of played around. I put in the Vermont Sentencing Commission and in consultation with the network. We could expand that if that's where you want to go with that, which is keeping it with the Sentencing Commission, and we could add other groups if you'd like, or wherever you want to go.
Well, if we could go back, if we could add groups like we did with the Justice Reinvestment 2 in consultation with, and I think the representative.
The same groups?
Not necessarily, but
Okay, I'll look at that. I'll check in with Ben and ask.
But definitely leaving, adding the Vermont Freedom Fund.
Okay.
And
Senator Baruth has a question.
Michelle, I'm wondering if you can just scroll up to the top of page 2 or up into page 1, I guess. Okay, right. You've already struck it out. I was looking at line 20 in the original, and you've struck it out, which I think needs to happen. So
correct. Yep.
Great. Thank you.
Mm-hmm. So another issue, in addition to who would be taking a look at this issue, is, what I've heard in the testimony is that it shouldn't be quite as predetermined around elimination of cash bail necessarily, but kind of a broader discretion for the group to look at. So I just wanted to kind of hear if you had any direction for me in there. I mean, it's was entitled, the bill as introduced was, eliminate cash bail. And I still have that in the title, but then I was thinking, is it to develop a proposal to reduce the use of cash bail, or what is your, what would your direction to this group be?
I think that, I think I would use some of the language that we've heard, that cash bail creates inequities within the system. And, while it may not be a proposal to eliminate cash bail, a proposal to eliminate the inequities within the system would be a good starting place.
Senator Bohosky has a question.
Yeah, not a question so much as a comment, but and I think I said this in the last hearing as well, I actually think that the proposal should absolutely be to build a system of accountability and eliminate cash bail in its entirety. What we're hearing is that the system is absolutely inequitable, and we know that there's almost 200 people sitting in our correction system because they haven't posted cash bail on any given day. And granted, that's not just misdemeanors, but I think it points to, again, as I said earlier, the importance of really looking at eliminating the system in its entirety. So for me, the expansion in this proposal is building a system of pretrial support and accountability so that we can eliminate cash bail. My thoughts.
Well, the only problem, actually, I don't. Alternatives to cash bail is what you're saying, I guess. How to hold people accountable without use of cash bail.
Yes.
I just want to chime in. I mean, I support if I'm understanding it correctly, I support that idea, but I mean, for me, the most important thing is looking at domestic violence and stalking, for instance. And just with the caveat that I know cash bail, as it currently stands, cannot be used for those crimes. They're misdemeanors. But at least for me, I just have a focus on those violent misdemeanors where, I mean, half of the homicides in Vermont stem from domestic violence. And I hope we are also looking at alternatives to keep those victims safe as we explore this. But aside from that, I'm supportive.
So I would be also supportive of in section 1 listing those 4 crimes.
So those would be domestic assault, violation of a protection order.
Yep.
Stalking.
Yep. And failure to comply with sex offender registry.
Sex offender registry compliance. Okay.
Senator Bohosky has something.
Yeah, Senator Hashim, can I just clarify what you're asking for? Are you asking for us to continue to use bail for those 4 crimes, or are you asking us to put that into the study section in order to build a system of safety?
I'm asking that we continue to allow cash bail for those 4 crimes.
I think that might be unconstitutional.
I would say that, I mean.
Well, it's constitutional now, so I don't know why it wouldn't be.
Well, because we're explicitly naming violent crimes and we can't use bail to mitigate violence. We can only use it for failure to.
Well, yeah, but
I'm trying to understand what Senator Hashim is asking for.
Yeah, so my fault for not articulating properly. So we can't use cash bail for just domestic violence misdemeanors as it currently stands. But there are instances where it has been used when there are other elements in that nexus, like a failure to appear or risk of flight, or no ties to the community. So I do think that it should be incorporated into the study so that we can figure out how to keep those victims safe without misusing cash bail, if that makes sense.
I don't think what I suggested was unconstitutional, by the way.
I'm not suggesting that.
I would have another concern, which is we've seen whenever we list, the administration comes in and wants to expand the list by a significant number of crimes. So I think what we would eventually wind up with is alone, as we have in other bills where we're articulating lots of crimes.
Then I'd suggest we don't do section 1 then.
You do have in section 2, the report back to you December 1st of this year with regard to a proposal. So, and the section 1 is not supposed to take effect until 2025, July 1st. So if you didn't do section 1, obviously, arguably, you can develop a proposal based on the recommendations that you receive in December and still meet the time, still have it take effect by July 1st if you chose to go that route.
Understood. Yeah, no, that's why
I certainly agree, Senator Hashim, that some explicit language in the study around that accountability and safety is really important as we move forward.
Yeah.
We got about 5 minutes left before we take a break, and then at 10:15 we need to look at S14. So,
I also think it might be helpful, and unfortunately, none of the national experts in this arena were able to be here today, but to hear from some of them, as we said last time, about what has happened in other states and the ways other states have moved forward. I think that might help inform this as well.
okay,
And I'll keep working with Peggy to try and get some of them here, hopefully after the break.
Senator Norris, do you have any thoughts on this? On the spot.
Yeah, I have a lot of thoughts on this. That's not exactly where we are now. I'm not saying I'm opposed to eliminating bail. I'm not saying I'm supportive of either, but so far all I've heard is a lot of very intelligent opinions, things based on emotions. I haven't seen the data other than the 37 misdemeanors that are currently incarcerated. I know that they spoke about data, whatever else. I couldn't vote on this comfortably without first getting the report back from the committee that's going to study this, as to whether or not we're going to carve out certain things or not carve out certain things. I'd want to know what those are. I mean, because basically this, until Senator Sears just said those 4 instances, just eliminating misdemeanor cash bail, and our own Defender General said it's not really a problem in the state of Vermont. So show me the statistics that we should be looking at this more seriously. That's all I'm saying.
Yeah.
And they may be there, but I need to see them. I need to hear them.
Where can we get those statistics? Department of Corrections?
Dick, thoughts on that?
but no, I think that's why we should involve the Sentencing Commission and rewrite the section 2. I agree with Senator Norris that it got the cart before the horse, perhaps, in section 1. And since it's not effective anyway until after the report is due, it might be better to save that for the report, which would give it more one way or the other.
Senator Sears?
Yep.
Before we close out, can I just ask where folks are on section 3 with regard to the judiciary directive to develop a proposal for notifying people
I think it's
about hearings?
I think it's probably the most important thing in the bill right now.
But no changes?
I didn't hear any from testimony, but then I might have missed some of the testimony. But I really think given what I've heard in the community and on other issues, that people's failure to appear, particularly post-pandemic, with many of the cases being so old, having a hard time finding the people not knowing. And then you just, you're stepping into more and more of a swamp when you fail to appear. Now you got that. Now you got another one coming at you. So yeah, I think we need to make every effort to get a hold of people. It also is frustrating for victims and others even the defense attorney who's waiting for the person to appear in court that day, and there's somebody else that they can't deal with. And prosecutors, the whole system is just bogged down by this failure to. I don't know if other committee members have heard the same.
I certainly support section 3 and that development of a notification system. From all of my research, that is the most important thing actually in making sure people return.
I think section 1 is great.
Yep. I can't remember if Judge Zone had suggestions there, but
We're still trying to find a time to meet, but I'll ask him, Senator Sears.
okay. Fine.
Our schedules are very busy.
Yeah, I know. It's
So I'll play around a little bit with the language regarding the stakeholders and their directive in preparation for the next meeting, but it sounds as though you want to hear from some additional witnesses.
Senator Bohalski has a list, and I'm happy to hear from people.
Okay.
I just warn us that we're fast approaching the crossover deadline, and we may have other bills we have to deal with the week after town meeting, so. If we can, deal with section 2 and 3, I think the rest, the bill could go very quickly, even if we hear other information and people focus on both those sections. That makes sense. Okay, why don't we take a break till 10:15 and then we'll be back on S14. Thanks, Michelle, and all committee and witnesses. Sure.
Dick,
Yes,
this is an odd request, but can I use a little of your hand cream?